কোর্টত কি দিছিল বুঝানে এখানে মানে আগতে এখন কোর্টত কি দিছিল ফ্রেশ পাইছো ফ্রেশ যদি এখন কোর্টত কি হয় এখন পাৰ্ট হৈ আছে এইটো হিয়াৰিং চলি আছে কিবা ৰেকৰ্ড চলি আছে কিবা ৰেকৰ্ড লাগে অলৰেডি হাৰ্ড সাইড নকৰো তুলত অৰ্ডাৰ
The first petition.
yes madam
So, yes, tell me. We have to see 37.
my lord
Can record is come. Charge has been framed. No?
Charge frame, my lord, as per order
11
dated
11-2.
recently frame 11/3/26.
Next date.
And the petitioner is at Silchar Central Jail, my lord. Initially, he was transit to West Bengal, my lord, Coach Bihar from Silchar.
Oh, that matter, no? Okay.
My lord,
Now he's in Silchar.
Silchar, my
I
lord.
see. Okay. As you know, since if 37 is applicable, then we have to see the merits, right?
My lord,
At least to some extent.
my lord. Maybe examine, my lord.
No. I mean that aspect, looking at it that way would have been easier, because the thing is that considering the stage of the case, though, if 37 was not there, then he could have been granted bail, considering stage. But here, since 37 is applicable, so we have to see whether there are any materials.
Right.
Probably there will be materials. Probably.
Earlier occasions, your lordship passed the order regarding the trace map and other after perusal of the case record, my lord, TCR, my lord.
Which order? Which order? Order dated? Acha. Part heard. Perhaps some notes then.
Petition is pending since, my lord, August, my lord. So your lordship
We have
passed
to
and
dispose it.
finally it was part heard also, my lord, your lordship.
Yes, we have to dispose it of.
And in this bail application, Ranat lower court, trial court also granted bail to one of the co-accused, my lord, Afzal Ras Purbuya.
Is it order is there?
My lord, I have already,
Annexed.
no, my lord, I have given to you also. Lower court order is there
Oh,
on 11/3, my lord. Here it is reflected 11/2, my lord.
11-2 is about charge framing.
Charge frame, but accused Afzal Ras Purbuya is also present after
Present after
being
being
released on
bail. He might have been released on. Was he released on merits? Because then we like to see the order,
my
right?
lord.
Because 37, as you know, is a very difficult
My lord,
test. It's a very difficult test.
my lord.
How many witnesses are listed in the charge sheet? Then trial will have to be speeded up. If bail is, if 37 test is cannot be passed for you. I have not looked into it actually, but then bail has to be, we have to, at least the trial can be speeded up. Are you in a position to say how many witnesses are in the charge sheet? I'm also looking.
Here the TCR is there, my lord.
Voluminous TCR. You can take one volume if you want. This one we can take.
In that case, my lord, order has been passed.
Charge sheet.
I have given to you that. Correction of homework. Consideration of sons, the higher rate. Send a pending. Seems one is a heavy shall open door, one another case is pending in Coast Bihar, my lord. So far as that is my lord Boxy, that is also my lord the NDPS case, my lord.
Where is the list of witnesses? Finding the list of witnesses in the charge sheet. Should be there. Thirteen witnesses. All of the killer, full stop. After completion of investigation, charge sheet was submitted in this case by CS number 6611 of 2025 dated 21/8/2025 under section 22C 2529 of the NDPS Act. Full stop. Subsequently, by the order dated 11/2/2026, charges were framed against against 5 accused persons, comma, one of whom is on bail, comma, under section 22C 29 of the NDPS Act. And next date is fixed for 11th March 2026 for commencement of prosecution evidence. Full stop. Let me see what is the narration in the charge sheet. 13 witnesses are stated to have been listed in the charge sheet. Contraband was seized from his possession.
No, my lord, not his position, my lord, and as per FIR, your.
Let us see the materials against him then, right?
My lord,
Let us see the, I'll just read this. We can read this narration in the charge sheet, the brief.
page 19 of the FIR. I am. He was present there at the time of search.
The present petitioner is Motiul
Motiul
Islam, Sebul Hussein Laskar, and under the Saidul Borbuya.
His e-rickshaw, my lord, I have also enclosed the.
50,000 Yaba tablets, right? Weighing 6.0. He was found in the house of Taramani Laskar.
Taramani Laskar.
He was found in the
Fine.
house of Taramani Laskar.
He is a e-rickshaw puller, my lord.
Huh?
I have also, he is a e-rickshaw puller, my lord. I have also annexed the registration certificate also. And his rickshaw was hired to deliver these cylinders.
These are matter of crime. These are matter of crime.
Well, let us see what are the prima facie materials against him. You just point it out, and if
And
necessary, I'll write it inside.
I will face, my lord. And I have been since 2052 days, my lord.
Yes, yes. Arrested on
10/6/2025, my lord.
10/6/2025. Yes, consider, no doubt. Yeah, switch on. Sound is okay.
On only. My lord. Bihar also, my lord, similar offense, my lord. Bihar PS case 86 or 25. That is also pending, my lord.
That is NDPS case.
But so far as order does not, I have placed before your lordship, my lord, that order does not reflect. But here it is mentioned on 29/1 order that the petitioner, the They are remanded back the judicial custody element. Accused Motiul Islam is produced physically from Cooch Behar District Correctional Home J.
My lord, Mr.
Now, West Bengal, they call it
West
correctional.
Bengal.
What is
With
the
the
case
police
number?
escort.
Kindly give me the case number.
25.
No, Coach BR PS case number.
The PS case 86 of 25.
Uh-huh.
Boxey Hut.
Boxy Hut. Spelling?
R
H.
HAT
Boxy Hut. Acha.
86 public 25.
Under
That
NDPS Act. Why I'm taking this? Otherwise, we can focus on this because under 37, you have to have fulfill two conditions. That he is prima facie not guilty and he's not likely to commit other offenses. So this is one factor, of course, which is slightly negative for him. Anyway, but let us see the prima facie materials. As the investigation implicated him also, let us see that. You have the case diary portions, right? You have the statements of witnesses. So many of these things are not necessary actually.
Paramount
Page.
page 19, my lord. When they went to
19 of
19 of their petition, my lord.
petition.
In the and bail application method.
Page 19 of their petition. Yes.
Interrogation, they stated that, my lord, both person, Taramoni and this person, that they have bought 2 cylinders from Sebul Hussain.
Page
However, they
19.
cut open the cylinders with the help of hammer and metal cutter. Accordingly, we searched the house and found 2 cylinders, which were cut, and also found 2 green color bag inside. My lord, that means the cylinders were already cut.
And next line also.
We searched the house and found 2 cylinders were cut and also found 2 green color bag inside, with 10 numbers of medium-sized packets wrapped in black tape transparent plastic found similar to the plastic packet which is found today early morning. Accordingly, 10 packets were marked.
And that ceremony was
That-
recognized by the another accused Sebul
Yes.
also.
Delivered to them. my lord.
Yes.
And
That was
is
the chain in which
Yes, that is the
they came.
chain, and that is the prima facie case, madam. Whether how it came, how these are matter of trial. madam. At this stage, we'll only say prima facie.
I am also not on this, my lord. Since my lord, period of detention, considering the period of detention and accused already appeared before the court, my lord.
No,
as
that
reflected
in a
in the
normal
order.
course, certainly. We would have considered that, but here we have, as you know, 37 prima, it is even more difficult than UAPA, that it's, you have to say prima facie is not guilty. That means
Right.
there's no material, suppose.
Right.
For example, one good example will be something like this, that suppose the only incriminating material is a discovery from his body.
Right.
And clearly 50 is not complied, suppose.
Right.
Then you can say that he's not likely to be guilty. Easy example, suppose. But otherwise, that's why you just take this and guide me.
And the implication is different.
I'm just referring to this, my lord. I am just referring to this.
And wherever 37 is applicable, any bail order passed without considering 37 will be invalid.
And my lord, this parity will not come.
I'll see it properly. You just go through it once. You can just mark it.
Passing the order now, after some time, if that I can,
After some time.
after some time,
I
I
have
see and I
because
can mark it. my lord.
DB is not sitting now.
Yes, ma'am.
I have some work, judgment work that I'll do and do this.
I will mark it by the time.
You can see it, and if you want to make any submissions, you can make it now, if you want.
Not, I guess. At this stage, my lord, let at least bigger witnesses be examined.
So what you do is you just see it and you, whatever you think are the materials with regard to him, you mark them. I'll go through that, then make an order.
My lord, at this stage, I am only praying for a period of detention, my lord, and
That is there. If we pass the test of 37, then all these things can come, and then it is certainly he is in custody for a considerable period, no doubt, no doubt. And case is also now proceeding for trial. So only thing is this 37. Just to be
That's
seen.
the only prayer.
I
My
understand.
lord, perfect. And he is only a rickshaw puller, my lord. E-rickshaw puller. I have
The-
also annexed the registration certificate.
The learned counsel for the petitioner submits that the petitioner has been in detention since 10/6/2025, and trial is also commencing. So it is submitted that he is a petty e-rickshaw puller, e-rickshaw driver, and he's a poor person with a family to look after. So, on the other hand, Mr. Kaushik learned additional paper contains that the implicating materials against the petitioner, and that the same is also narrated at the time of lodging the FIR itself. So it is submitted that at least the seizure witnesses may be allowed to be examined before considering bail. The allegation in the FIR is about recovery of recovery of 50,000 Yaba tablets suspected to be narcotic substances, suspected to be psychotropic substances under the NDPS Act from two of the co-accused. And the present accused petitioner was arrested in the course of the initial investigation.
That another case is pending.
But
Yes.
the learned additional PP also further submits that one Proceedings PS case number 86 of 2025 under the provisions of the NDPS Act is already pending against the present petitioner in the state of West Bengal.
The period sustained by him, my
Huh?
lord, period undergone by him, my lord, that is not, my lord, that cannot be termed as a prolonged incarceration if my learned friend is taken. that
Okay,
plea,
you
my
want me to record that? Should I? The prosecution further submits that due to the length of detention would not be sufficient ground for grant of bail in the facts and circumstances and at this stage. I'll go through it. You just go through it and mark.
And another, just one point, I.
Yes, sure, sure.
In respect of another case, my lord, that is pending at West Bengal, my lord. If your lordship, suppose your lordship allows me bail, my lord, but he will not raise automatically until and unless he will not get from the West Bengal, my lord. So that part your lordship may also consider. That is my humble submission.
Okay, the first challenge is to pass 37. If test like 37 is passed, other things becomes a normal bail application.
Told her he is a habitual.
Yeah, no, because as I said,
I
for
don't know.
37, yeah, other cases are relevant because two determination has to be made, right? Next matter.
Obliged.
It is earlier rejected by your lordship.
No
and
issues.
Now lordship, we are on 78 days.
Okay.
The victim died. And the allegation is upon me in the FIR as because I took him out of the house lordship as he being my friend, as he due from the FIR. The incident occurred on 25/11/2025 and the FIR was lost on 1st of
I see.
December.
4-2, no? It was rejected on 4-2. Is 18.
Wait to type him around.
My lord, here last occasion, I was supposed to bring my lord the final postmortem report. Here
That's
what has
come.
happened, my lord, opinion regarding that has been reserved, my lord. The visara has been sent to FSL. Till now, my lord, report has not come.
But the visaras take their own time, I'm
But
telling
it
you.
takes time, lordship.
Visaras take their time.
That my lord, earlier lordship has perused this city and rejected their.
What is the progress of investigation after 4-2?
My lord, they are now waiting for the visara, my lord.
Otherwise, it's complete.
It seems, my lord, that they are searching for these persons, my lord, and some witnesses are also yet to be. Otherwise, there are eyewitnesses, my lord.
That's true.
Basically, Lordship, that regarding that, he is a drug addict, Lordship, victim, and he had some teasing one girl, Lordship, and the family member of that girl, Lordship, they have assaulted him, Lordship. My part is that, Lordship, I, being his friend, I called him from his house, Lordship. I picked up him on my motorcycle. Whatever, maybe, Lordship, 78 days, Lordship, I'm a local person of that said locality, Lordship. I'll face the trial, Lordship. I'll cooperate with the
So
investigation.
you said some witnesses remain to be examined or almost done.
My lord, IO,
Ah.
here that is, I have not written, my lord, CD, because CD is of up to 8-1, my lord.
Just let me have a look. So probably it is complete. Anyway, we can see.
One, not over 18-2, Lordship.
I'm sorry, my lord, 22-1. 20.
Nearly month,
Okay.
Lordship.
Yes, Munir, you heard, and
Assaulted
our
the
portion.
person
Is
in
it true? True.
But means, Lordship, the names which reflects on the FI, Lordship, belong almost to one family, Lordship, except me. My name is embroidered at serial number 1, Lordship, that on page 13, Lordship, of the FIR, that Lordship can see. The other rest of the part, Lordship, 2, 3, 4, 5, 6, they belongs to the same family, Lordship. They are related, Lordship. Because the girl which was teased, Lordship, they belong to this family.
Para 2, 2, 3, 4. An earlier bail petition was rejected on 4/2/2026 in BA number 27 of 2026. Full stop. Munir Learned Counsel submits that in the meantime, the petitioner has spent 78 days in custody,
78.
78 days in custody, and seeks bail at this stage in the subsequent petition.
Here, one thing I would like to submit, my lord, because the last occasion it was rejected on 4-2. Prior to the CD came to our court, my lord. Obviously, there will be no, police cannot do the investigation. That period CD was here. Then 4-2, then it went back. Then again, my learned friend, they have filed the.
So it was brought back again.
Again brought back.
Not much scope.
And that the gap is also there, Lordship, 25/11, the incident occurred and the FIR on 1/12. Lordship. That part may be also taken into consideration.
This was again listed, they filed and that was listed on 10-2. Immediately came.
It came back.
Lordship, 2 CD remains, Lordship, one in police station itself. One CD.
But we cannot keep here.
No, they-
We cannot keep.
It is totally as a.
Oh, PM report is here, no?
Final opinion is not there.
Okay, but otherwise PM report is here.
Last time PM report was not there, I think, Lordship, while rejecting the petition. It is PM machine, no? Reject for us, no? Nothing, PM to 9.
I don't remember whether PM report was there or not. The learned additional PP submits that after the date of last rejection, though the case diary was sent back, but it had to be procured again. Soon after, due to in this subsequent bail petition. Nevertheless, on perusal of the case diary, it appears that the forensic report is awaited. Forensic report is awaited to finalize the opinion regarding death. However, the postmortem report is available. The report also reveals multiple needle puncture marks
It is a drug
And
addict lot.
seen
It's
over
implicated.
both cubital fossa area. In this context, the learned counsel for the petitioner submits that as per his instructions, the deceased was unfortunately into taking drugs. What are the injuries found? Injuries. Postmortem does not reveal any injuries. Hmm? Huh?
Eyewitnesses version, my lord. That
Yes,
has been
yes.
marked.
About assault, but it should have been reflected. I find that during investigation, the statements of several witnesses have been examined. And statement of one witness, purportedly an eyewitness, has also been recorded before magistrate. Full stop. It appears that significant part of the investigation is already over. And the FSL report is awaited to finalize the opinion regarding that in the postmortem report. In the postmortem report, though, some of the organs like lung, brain, etc., have been mentioned as congested, but apart from this needle puncture marks, I have not noticed mentioning of any injuries. I have not noticed. Have you?
Perhaps I have also not.
I've just cross-check it once.
Overdose of overdose of drug.
The learned counsel for the petitioner reiterates his submission that reiterates his earlier submission that the petitioner and the deceased were in the friend circle.
They're friend logic.
Friend circles. Full stop. Considering the facts and circumstances prevailing at this stage, including the progress of investigation and the up-to-date length of detention, it's not there. Dash. I'm of the considered view that perhaps this subsequent bail petition can be allowed at this stage. And some of the matter. 30,000 with 1 slot. Subject to the condition. Cooperate, not hamper, semper. Return the case diary.
CGM Sri Bhumi lot.
Sri Bhumi. Concerned learned court, CGM Sri Bhumi.
Sri Bhumi.
Sri. Okay.
Much obliged, your lord. Much obliged.
Okay. Tomorrow, what is my roster? I don't know. It has come. That bench will continue. No,
That will not continue. Your lordship is sitting in court number 2.
but
Michael, my lord. And one, my lord, before that, my lord, there is a full bench of Justice Michael, my lord. Then that bench will sit. Before that, your lordship has a single bench.
Okay.